All right, we'll now be going back to the story of governors being sacked, where the senior advocate of Nigeria, Femi Falana, expressed deep reservations regarding the recent judicial decisions made by the appellate court that annulled the victories of Governors Abba Yusuf of Kano State and Caleb Mutfwang of Plateau State. Now, joining us on the news to discuss this further is Festus Ogun. He's a human rights lawyer, and he's here to discuss this. Good afternoon, and thank you so much for joining me, Festus.
Thank you so much for having me.
All right, so tell us, Barrister, do you also have reservations regarding the recent judicial decisions made by the appellate court to sack governors of some of these states? If yes, please go ahead and tell us what they are.
I absolutely believe that the judgments coming out from the tribunals, or some of the judgments coming out from the tribunals, coming out from the Court of Appeal in recent time are quite disturbing. Disturbing because they seem to be inconsistent. There are decisions from our court, especially when it comes to election matters, pre-election and election petition, that are inconsistent. Consistency is the soul of the judiciary. The judiciary has to be consistent in its decision. So when you have a situation where in a court of appeal in Lagos says, oh, when you have this kind of situation, this should be the position of, this is the position of the law, and this is what should be done. Then another court of appeal in Kaduna is saying that on the same issue, is saying something entirely different. That gives us a lot of worry as citizens of this country and as lawyers, ministers in the temple of justice. Let me give an instance. In the case between His Excellency Mr. Peter Obi and INEC and President Bola Ahmed Tinubu and the APC, the Court of Appeal and the Supreme Court mentioned that when it comes to issue of subpoena not filed alongside the election petition, that, well, it will not be admissible if the subpoena is not filed alongside the election petition. But we see, in fact, the court in that case regarded a subpoena witness as a witness of the petitioner. Now, in the case of Abba Yusuf and INEC, the Court of Appeal said no, that a subpoena witness is not a witness of the petitioner, that a subpoena witness is a witness of the court, and so their testimony can be admissible even after the expiration of the date meant for filing the suit. So you see that there are inconsistency here and there in our electoral jurisprudence, and it erodes the faith that our people have in the judiciary.
All right, Festus, it's actually quite an interesting, angle where you talked about the inconsistency in some of these judgments. But, going back to the electoral issues now, to avoid a gap in governance, the need for electoral issues to be quashed and also resolved before swearing in or even commencement of incoming administrations has been re-emphasized over and over again. Now, I would like for you to tell us how achievable is this considering the pace of our judicial process?
Well, election petition is sui generis. It's a special proceeding. Election cases are quite different proceeding that has its own rules and regulations. Now, I do not see any reason why an election petition should take 180 days in court. The date has to be reduced. I also do not see, a lot of reasons why we should spend 60 days to determine the matters at the Court of Appeal and for the governorship that gets to the Supreme Court another 60 days. I also do not see any reason for that. So I'm of the respectful view that again our constitution should be amended so as to reduce the time spent on proving or presenting an election petition. But you see, that is just on the one hand. One important point, still on the issue of inconsistency, that I would like to make is on this issue of, if you look at the Plateau judgment. Whereas in a decision, in fact, in plethora of decisions, our court, from the trial court, from the tribunal, up to the Supreme Court and the Court of Appeal, have been very consistent in holding the view that issues relating to nomination of a candidate, issues relating to primary election, are pre-election matter that cannot be litigated at the election tribunal. Oh, how this person is nominated, or whether a convention was properly conducted, or whether this person was properly nominated by his political party. It is an internal affair of the political party, and our court has held consistently that they are not justiciable, not even at the election tribunal. Even at pre-election matter, a rival political party cannot challenge the nomination of a candidate of another political party.
Okay.
When they are not actually participated. So you see, these decisions are quite confusing, and for me as an election lawyer, it gives me a lot of cause to worry.
All right. Festus, now inconsistencies, seems to be our watchword in this conversation. But even the SAN, Femi Falana, did talk about some irregularities on the part of INEC. Now, I would like for you to tell us what are the legal consequences or even implications of sacking these governors, especially when some of the irregularities listed were blamed on technicalities on the part of the electoral umpire, which is INEC, and also in some part on the political parties themselves?
The way I see it is that I think we are getting to that stage in our political history when the duty of lawmaking, the duty of electing leaders is now being passed to the court. Why should a candidate duly elected by the people be taken off the seat just because of the failure on the part of INEC? Why should a candidate who has been elected by the people be made to pay for the crimes of INEC? I mean, these are the issues. We have to tell the truth to ourselves that we have gotten to that point in our history that our court has to do away with barren technicality, and our court needs to embrace substantial justice. Election petition, the process, I've been involved in quite a number of election matters, pre-election, post-election. And I can tell you that they've made the electoral jurisprudence so technical that when you go to election tribunal, if up to the Supreme Court, the fixation is usually on technicality, which should not be so. So why should a person, a candidate duly elected by the people, why should the wishes of our people be subverted by the incompetence or the inadequacy of INEC? I'm afraid that our democratic ideals are being eroded away when the courts are now the ones putting our leaders to us. And that will be an invitation to anarchy.
Thank you so much, Festus Ogun, for your thoughts on this particular topic. We really, really appreciate you for your time and also speaking on this. Thank you so much.